Ladies and gentlemen, thank you so much for coming and welcome to our panel on SOPA, PIPA, and the future of IP protection. I think if you can pronounce the acronyms, then you're in the right place. It's something of a tongue twister, SOPA, PIPA, picked a peck of pickled peppers. But we are going to go behind these arid and technical initials and talk about one of the most gripping questions in the area of legal policy today. What is the role of digital activism in transforming our debates about online privacy and free speech and intellectual property? We have a remarkable panel to discuss this question, and we want to explore all aspects of it. In the one sense, the web protests that took Congress by surprise and unexpectedly killed support for SOPA, which is the Stop Online Piracy Act in the House, and PIPA, which is the Protect IP Act in the Senate, are a cause for dancing in the streets. I think no one expected in the weeks leading up to the protests how swift their effect would be and how quickly they would block bills whose passage had been thought to be rather inevitable. And we're going to discuss the role of digital activism in this debate. And I think few people on this panel would dispute that in their current forms, the forms that were defeated, SOPA and PIPA may have been a heavy-handed response to a very real problem. But although there'll be some disagreement about exactly where the line should be struck. But even as we celebrate the end of SOPA and PIPA, we need to delve more deeply into this fascinating question. After all, this wasn't just a battle between the paragons of free speech and the defenders of the interests of the old media. There were financial interests on both sides of this debate. There was a protest song that sprang up in the middle of the debate that said, "Our web means more than lawyers, lobbies, and lies, so we speak up before the internet dies." But there were, of course, lawyers and lobbyists on both sides of the debate, and neither side was devoted to the promotion of creativity for its own sake in every case. Ultimately, it may be too simplistic to see the copyright wars as a battle between idealistic tech companies that want information to be free and the greedy old media that wants to preserve a dying business model. There's a very interesting new book called Free Ride, How Digital Parasites Are Destroying the Culture Business and How the Culture Business Can Fight Back by Robert Levine. And Levine argues that the real battle is between two competing business models. On the one hand, there are publishers, record companies, and movie companies that fund the content that people want to watch and read. And on the other, there are tech companies like Google and Facebook that want to distribute content created with what Levine calls, quoting Louis Brandeis, other people's money and sell more ads as a result. By destroying the business model that makes it possible for AMC to invest in excellent shows like Mad Men, Levine argues that tech companies will create a digital wasteland dominated by self-produced cat videos. I want to explore with our panelists whether Levine's critique is correct. It's not obvious, for example, that online piracy is the major factor allowing tech companies to distribute content for less than they paid for it. Levine cites the example of the music industry, which was so spooked by the proliferation of pirated music on Napster that it struck a bad deal with Apple, replacing the sale of $15 albums with 99-cent songs. But it's not clear that the same result wouldn't have occurred in a world without Napster. Individual bands might have struck enough deals with Apple that the music industry would still have been forced to sell the content below the cost of production. We need more empirical research about the relationship between copyright enforcement and digital creativity, and we have the world experts to explore this question today. We'll also explore, in addition to questions like the impact of digital activism and the relationship between copyright and creativity, alternatives to SOPA and PIPA. One that won bipartisan support promoted copyright without changing the architect of the internet. And that's simple law enforcement of the kind that ensures there's less commercial child pornography available online than there was 15 years ago. That was the approach taken in a 2010 report by Victoria Espinel, who's the White House copyright czar, that suggested that the best way of combating international piracy is to enhance foreign law enforcement cooperation and strengthen intellectual property enforcement through international organizations. Since the number of commercial pirating sites operating overseas is arguably small, a couple dozen by some estimates, tracking and identifying them and prosecuting them in cooperation with overseas police forces may be a more focused alternative to the problem of internet piracy than shutting down free speech for everyone. So those are some of the questions that we're going to be discussing. Let me very briefly introduce our panel, since you have their full bios, and then we're going to jump right into our discussion. We have Gregory Barnes, in alphabetical order, who is Director of Government Affairs at the Digital Media Association. We have Stephen Metalitz, who's a partner at Metalitz, thanks, who's a partner at Mitchell, Silverberg, and Krupp. Stephanie Moore is the Democratic Chief Counsel on the U.S. House of Representatives Subcommittee on Intellectual Property, Competition, and the Internet. And Catherine Oyama is Copyright Policy Counsel at Google. Thanks to all of you for joining us and sharing your time. And I will begin, I think, with Stephanie, if I may, just to help us understand what were SOPA and PIPA. In addition to the acronyms, what did they propose and try to do? What were the leading arguments for and against them? And what was your perspective on the way the debate unfolded?
Thank you, Jeff. Let me first make my obligatory comment that my comments here are my own, unless otherwise specified. And one other point I'd like to make in homage to my center counterpart, I would like to say that PIPA is a non-word. The bill in the Senate is the Protect IP bill, not PIPA. I mean, I know it's easy and makes it go in sync with SOPA, but Protect IP was already an acronym, so it really should be Protect IP and PIPA. But, you know, just because my Senate counterpart is very annoyed with PIPA. PIPA is the Duchess's sister, not a bill. So,
it's getting into as much trouble as she is as well.
Yes, exactly. So, forgive me, but this light is really blaring.
It is blaring.
In my face.
So you won't talk, eh?
Good point. You know, both Protect IP and SOPA attempted to address a problem that has been around for some time. I mean, the House Judiciary Committee has considered numerous bills over the course of my tenure there that did indeed recognize that piracy online was a problem. I think that what we attempted to accomplish in SOPA, I don't really want to speak for the Senate's bill. There were some things that we did differently, but the main problem that on our side of the aisle, in any event, we saw was that the proliferation of online piracy is affecting jobs, it's affecting creativity, and it's affecting consumers, all in negative ways. I do think that there's the untold story about SOPA is that we were not, it seemed to be this struggle between these titans, the tech companies and movies and music. However, at least, you know, from a legislative perspective, we looked not only to the harms that were visited upon the movie and music industry and looked beyond that to counterfeits online. Part of the untold story is that many trademark holders were indeed hesitant to go out into the public and discuss that their products were the subject of rampant counterfeits, particularly those types of products that would harm consumers. But I will say that you know, you do have online products other than the pharmaceutical market. I will say you do have online products like perfume, toothpaste, other foodstuffs that can visit incredible physical harm to consumers that purchase them at a discount, thinking that they are receiving a deal. So we were very, very, very cognizant of that fact. However, the movie and music industry seemed to be the only industry that could safely go out front and make the argument that online piracy was a problem. I will say that we were encouraged at some point to separate hard goods from digital goods. That would not work for a couple of reasons. First of all, we protect intellectual property in whatever form. So trademarks, copyrights, and patents all should be subject to the same protection. But number two, I think, again, part of the untold story, or certainly not picked up on to any degree of popularity, if you will, is that the IPR Center, which is in Virginia and dedicates itself, it's a consortium of U.S. agencies that dedicate themselves to looking at IP theft, have certainly seen linkages between the theft of music and movies and other organized criminal activity. So when one encourages, I mean, again, in the media is Kim.com and Mega Upload, and people just simply think this is a fat cat in more than one way. He is a pretty large guy who was pilfering music and movies to just sustain his luxurious lifestyle. But there are others who also take movies and music online and use it to fund other criminal activity. Again, the IPR Center has linked organized crime to human trafficking and other drug crimes. So I think that the problem was far more expansive than the public was led to believe, and I will stop there. And
That's great. That's very helpful, both to have your sense of the magnitude of the problem and also some of the difficulties with the bill. Gregory Allen Barnes, can you tell us more specifically what the main objection was of the digital activists and others to the bill? The claim was that it would change the structure of the internet in an effort to enforce IP. What did that mean, and what was the position of the Digital Media Association on the bill and your perspective on the debate?
Well, it's about a three-part question. Let me start by kind of, I guess, setting the stage, touching upon some of the points that Stephanie covered, and then getting to, I think, the second and third part of the question. As a trade association that represents several of the leading licensed distributors of music and movie, we kind of had a very interesting perspective, and I think maintained one that's really balanced. On one hand, our companies, and you guys are very familiar with them, I'll just name a couple, I always get in trouble, but iTunes, Amazon, Microsoft, we represent YouTube, Slacker, Rhapsody, so we're in the internet radio sphere, we operate online music stores, we allow you to stream movies, download movies, and watch them digitally. So on one hand, we pay an inordinate amount of money in licensing fees to copyright owners. So to that extent, I mean, we join with copyright owners in being very concerned about the ability of users to go to these quote unquote rogue websites, which, since Stephanie's concerned about certain terms, I'll say that rogue website is also a loaded term as well, because I mean, we don't, it's hard to define one. It's kind of almost like the definition of pornography. But we are concerned about those sites that allow for users to gain access illegally to copyrighted material. Because the more that you go to those sites, of course, the less likely you are to purchase or download legally. However, at the same time, when we see legislation like SOPA and Protect IP, there's a concern that the way that these bills are drafted, they're drafted in such a broad fashion that not only in many times in these bills in particular, capture bad actors, they actually have, I think, unwanted, unintended consequences against good actors that are in the business of innovating and distributing legally distributing online content. And so our concern is that area. Now, to drill down, I mean, there are a lot of concerns, and I want to do more forward-looking than backward-looking, but I think the biggest one from our perspective was with the definition of an internet site that's dedicated to theft of copyrighted material. And in particular, again, there's several different things I could point to in SOPA, but the one that I thought was most problematic from a collective viewpoint perspective was the attempt at codifying the willful blindness requirement. For those who aren't familiar with that, there was, in the bill as it was introduced, there was language that basically categorized all websites that that take steps to avoid confirming a high probability that that particular website is being used to engage in copyright infringement. What that would mean is a website like a Facebook, for example.
Well, let me interrupt, because one point that I didn't emphasize is that we were targeting foreign websites. Facebook is not a foreign website.
Well, the bill would allow domestic copyright owners to bring suit against domestic websites as introduced. Later on, in later iterations of the bill and draft amendments, it did ultimately approach, and again, now we're talking about SOPA, because SOPA and PIPA are different bills and it's hard to kind of describe them together. But later on, it did limit itself to foreign websites. So that issue was addressed. But initially, that was the biggest concern, I think, collectively, from most internet companies.
If it had been limited, and the fact that it was limited to a foreign website did not satisfy your members, you were still opposed to it in that form as well?
I don't want to speak, our members, again, we represent a wide swath of members. As a trade association, we weren't as concerned when the bill got to the point where it was limited to foreign websites. That is correct.
Great. Catherine Oyama, you are the Chief Copyright Policy Counsel of Google. Google was celebrated for its role in this debate by digital activists, where it was seen to be on the side of the angels, and there was a lot of happiness among the netizens and Google on this issue. Why was it that you were seeing eye to eye here? What were your objections to SOPA and PIPA, and how do you see the future of the debate?
Great. Thank you. I guess similar to Stephanie's caveat, I guess I should just preface with the fact that I do work at Google, so I could talk for Google. It's going to be tough to speak for the entire internet or for the entire, digital activist revolution when it encapsulated something like 15 million folks that contacted Congress and 40,000 websites. But I guess just to give you a little perspective from Google's point of view, I joined the company, I think a couple months before the Senate introduced the Protect IP bill. And the major kind of goal that I had heard about the bill was that there is a problem of foreign rogue websites. These sites are kind of considered the worst of the worst. They are dedicated to infringement. They traffic only in other people's property, and that there is a law enforcement jurisdictional problem in the United States because these sites are based abroad, and that Congress and rights holders were looking to intermediaries, so other players kind of in the technology internet ecosystem, to kind of step up, pitch in, devote some of our resources, and help tackle the problem. None of that sounded objectionable to us. We actually have kind of, absent legislation, extremely robust IP enforcement, programs, from going after counterfeits, because that's an awful user experience in our system, to fighting copyright infringement, things like that. I think the problems are kind of twofold. So one is process and one is substance. I guess taking the second one first on substance, I think we were kind of, frankly, shocked when the legislation came out and people that know this area very well reviewed the text. It was so much broader than had been advertised. There was kind of a visceral response within the technology and the internet industry that this bill, intentionally or unintentionally, was aimed quite directly at legitimate sites and at sites in the United States. So in terms of the scope, we had heard we wanted to pass legislation that went after foreign sites. up until the very end, Protect IP always had a large section on US sites. I don't think there's any debate about that. The proponents would say, there's reasons for that. And SOPA, for a very long time, had a large section about US sites, and in the end, it was modified somewhat, never to kind of the satisfaction of people that were raising the concerns. There had always been this understanding that we were going after the worst of the worst. So sites that kind of everyone would look at, say, these are bad guys, they're clearly violating the law. The definitions of what is a site dedicated to infringement clearly expanded the scope of copyright law. So it was changing the substance of, very carefully crafted, balancing test, judge-made doctrines that, for decades have kind of served as the foundation for internet and for copyright law, and kind of in a few strokes of legislative text were in a lot of ways kind of simplifying or over, broadening what would be a liability. That created a lot of concern within the venture capitalists within Silicon Valley, because if you're a new company, you're starting up, you have an innovative idea, you need to know that your site is lawful. You need to have legal certainty to kind of get investments, move forward. So that was the definitional problem. And then I think in addition, there were some remedies. We feel that there are certain remedies that would be very effective.
Could I just ask on the definition, because this
Yeah.
is so helpful? You said intentionally or unintentionally. What do you think it was? Why was it expanded so much beyond foreign websites? Was it intentional or unintentional?
Oh, you'd have to ask the folks that wrote that, because, I just don't know. I think there's a concern about, infringement in the United States. I think there's also a concern about foreign. I think the problem is if you want to get consensus on passing legislation, then kind of what a bill does needs to match what it's being sold as. So within the United States, the DMCA, Digital Millennium Copyright Act, which Congress passed in 1998, kind of serves as the foundational law. I'm sure that there's a lot of people that have concerns about the DMCA. They want to amend it. That bill took a lot of years. It's a carefully negotiated bill. So if there's going to be a conversation about overturning the DMCA, that's kind of one legislative conversation. It includes certain stakeholders. It's more controversial than a very narrowly drafted bill that's truly targeted at kind of foreign rogue sites. And I guess the last thing I'd add, just you'd asked about our concerns, is the remedies. So in the internet space, there are certain remedies we think are effective for going after piracy and they're going after infringement. And they're basically using, either existing tools or new tools to target the source of the problem. Some of the remedies kind of would, for the first time, have the US endorsing new remedies. So the shorthand kind of in the web space was called site blocking. So either instructing domestic search engines to block full sites, or the most controversial thing in the cybersecurity field, you guys probably were aware of some of these conversations, was about DNS blocking, so kind of changing the way the internet works. And you had a lot of cybersecurity experts, not so much copyright lawyers, raising concerns about what that would do to the security of the internet.
Explain what DNS blocking is, because that's important for those who may not know.
Okay. Second caveat, that I am not an engineer.
We have some help, I'm sure.
But essentially, the main criticism that was coming from the cybersecurity community, there were folks like Stuart Baker, who's pretty well known in Washington. He's the former general counsel of the NSA. He's worked at DHS. Their main argument is that the cybersecurity field had spent about a decade rolling out something called DNSSEC, DNS Security Extension Protocol, to make sure that the DNS system for globally in the internet is more secure. So that means if you're typing in wellsfargo.com, that's a name. It's going to then be translated to a specific IP address. And there had been a big effort, both from the US federal government, from various agencies, and also internationally with other countries, to adopt this protocol to make sure that you basically had security as kind of a series of handshakes. When a user types in a domain name, that will always, you have certainty that that is taking you to a site, so that if there's a hacker and they're taking you somewhere else, that will be flagged as a problem. So what the engineers said is that these court orders that the legislation would mandate to ISPs would essentially break that chain, and that the security protocol really would not be able to distinguish whether or not that chain was broken because a court had ordered it or because there was a cybersecurity attack. I think their second concern, which was actually equally strong, is that there's kind of very predictable user behavior in the internet space. Like internet traffic, it routes around blockages. It's very hard to kind of stop websites and stop traffic. That's why we always think it's better to go to the source from a law enforcement perspective, like bust the site, take them down. But just kind of pretending that a site doesn't exist on the internet is really hard. It's always going to pop up. Like, these guys are extremely crafty and very sophisticated. And so their concern was that once you have these blockages, it's not difficult. Like a 10-year-old on his computer in 30 seconds can reroute his DNS traffic. you can go to an alternate DNS. So if any, court order is served on a US DNS provider, you could reroute to an alternate offshore provider. And then you're kind of in a no man's land. And so there's other types of security vulnerabilities that could introduce, like spyware, malware, those types of things. So I think in the end, on the procedural concern, these issues were being flagged by engineers. There was actually never a hearing on this issue. And so part of it is like a legitimate debate about where the right balance is. But I think the other thing that was happening was kind of a growing frustration that there are at least legitimate concerns and they need to be aired for us to reach the right decision rather than kind of running roughshod over all these hands that are starting to pop up.
Wonderful. Thank you for that. Stephen Metalitz, you've heard from your colleagues the sense that there were problems with SOPA and PIPA. There are legitimate areas of concern and better ways of addressing them. I wonder if you could tell us what you think those better areas are, and also help us focus on a question I know you've thought a lot about. What was the role of digital activism in changing this debate, and how is it changing debates about these issues more broadly?
Thank you very much, and I'll start with the same caveat that I'm not speaking for my clients here. I'm giving my personal views. I agree with about the first 30 seconds of what Catherine said, and then pretty much everything else afterwards I would disagree with. I think she correctly stated the problem that this legislation was intended to address, which is transnational sites that are dedicated to stealing American intellectual property. In the case of my clients, it's copyrighted material. In the case of many other of the businesses that supported and consumer groups that supported this legislation, it was counterfeit products with counterfeit trademarks. But that's the problem that it was intended to address. And that's the problem that remains unaddressed today because of what happened at the beginning of this year with these two pieces of legislation and the furor that engulfed them. I mean, it was a little bit, from my perspective, it was a little bit like somehow stepping into a barroom brawl. Everything's going on okay. Suddenly there's a lot of noise and commotion, incoherent shouting is going on. There's a blackout. Most barroom brawls do involve a blackout at some point. And, you wake up with a splitting headache the next morning and your pockets are empty. So we kind of went through that experience, and the result is we have this problem that everyone agrees is a problem, and we really haven't moved forward on a solution. Let me just, on the digital activism question, I think what concerns me most is not many of the points that Catherine raised, and particularly her last point, I think, is a valid one as far as how the DNSSEC issue was treated. But those arguments were not the arguments that derailed this legislation. Those arguments were not the arguments behind the blackout. Those arguments were not the arguments behind the thousands and hundreds of thousands of abusive emails that poured into Capitol Hill and really, to be frank, intimidated many members of Congress. I don't think there were arguments. I guess there were two tropes. I guess in the internet world we're supposed to call them memes. But let me talk about these two memes that I think were paramount in this debate and I think are very concerning. The first one is, this is going to break the internet. We heard that all the time, and that besides the fact that it underestimates the incredible resiliency of the internet, that was focused really almost exclusively at this one remedy that Catherine talked about at the end, site blocking. Site blocking is a remedy that law enforcement in most countries of the world and courts in most countries of the world have at their disposal to deal with this problem. When they have a site that they can't get jurisdiction over, but that is polluting their market with counterfeit goods and pirate goods and stealing jobs in their countries, they can order site blocking. It's true in Western Europe, it's true in India, it's true in a number of countries. Different rules apply, obviously, but this is if site blocking broke the internet would already be broken, and I think we can see that it's not. So I think the problem was overstated, and of course, what this legislation tried to do was provide some due process, some orderly procedure for a court, a federal judge, to decide whether or not site blocking should be ordered at the instance of the government, not at the instance of private parties. in a particular case. And I think if we're going to have site blocking, we should have it that way rather than the way some other countries do it, which provides a lot less due process. That was one meme. But the second meme that I think should be even more concerning to the American Constitution Society was the meme that copyright means censorship. And we heard that all the time, that this was a bill to promote censorship and give copyright owners or others the ability to censor what was on the internet. Now, it's not true. That's the least of its problems. I understand that in a political debate, you're going to have oversimplifications and you're going to have caricatures of your position. I'm used to that after 30 years of doing this. But this is a particularly dangerous one, I think, for people that care about the First Amendment, because as your speaker this evening wrote so eloquently, Justice Ginsburg, copyright's purpose is to promote the creation and publication of free expression. And she quotes Justice O'Connor, "The framers intended copyright itself to be the engine of free expression." And then she said, this is all from the Eldred versus Ashcroft case, "The First Amendment securely protects the freedom to make or to decline to make one's own speech. It bears less heavily," perhaps a bit of an understatement, "when speakers assert the right to make other people's speeches." So the speech we were talking about here was basically the right to steal the expression of other people and make it available, undercutting their economic model, the model that the copyright clause and the First Amendment work together to protect. That was really the danger that this legislation was going after. So I'm quite concerned that if the censorship equals copyright meme that was generated in the last several months takes off, it's wrong, and I think Justice Ginsburg has explained why it's wrong. We have a practical problem because the leading champions of the First Amendment in the Congress also happen to be the leading champions for strong copyright protection. You've got a problem there when you're telling Patrick Leahy and other champions of the First Amendment that they are supporting censorship. And I think it also is we have a problem of crying wolf, because censorship does exist in many of these countries, and countries do abuse some of these tools in terms of dealing with misconduct on the internet. So there really is censorship, but again, shouldn't the United States be trying to develop and propagate a system in which these decisions are made in an orderly, reasoned manner by independent arbiters with due process and opportunity to be heard? These were all features of this legislation. So I'm worried that we're set back on that we somehow will get mired in this argument about copyright and censorship, and that will not only make it harder to address this real problem that I think everyone agrees is a real problem and we haven't moved the ball forward on it, but it also will make it harder to have a good rational conversation about what our copyright policy ought to be in the future.
I guess, can I just chime in a couple of things on the First Amendment piece? I don't think it's fair to say that the digital activists didn't have some intellectual heft but behind their free expression First Amendment concerns. Starting with the Larry Tribe, constitutional scholars, forgotten more about the First Amendment than I will ever learn in my entire life. But he has a pretty lengthy memo kind of laying out his concerns on the grounds of vagueness, overbreadth, prior restraint, things like that. So I think I completely agree with you that copyright enforcement is not incompatible with First Amendment, with free speech. Obviously they're both incorporated within US law, but implementation and words for legislation really matter. The United States, I think one of the things that we had the greatest concern about, actually has been a tremendous leader on issues like free expression, and especially under the leadership of Secretary Clinton. She's been quite vocal about the need for an open internet, what that's done to kind of transform societies where people are able to use social media, to report on political events that are happening. A lot of times we're now seeing social media kind of lead news reporting. We've seen the open internet really facilitate a free exchange of ideas. I think when you have a definition that arguably does sweep in sites that aren't breaking the law, but that are legitimate sites that are allowing people to kind of use and post, I do think that raises a lot of free expression and First Amendment concerns as drafted. There were red lines and kind of language provided that would, I think, have addressed those concerns. And, hopefully one of the things in terms of moving forward is now there's an understanding that there are a lot of stakeholders in these conversations, and I think sometimes accepting some of those changes or modifying the language so that we can reach the common goal is a more productive path forward.
If I could ask our other panelists, I want both of you to intervene on this. There are two interesting themes that Stephen has helpfully put on the table. One is the relationship between free speech and copyright, and the second is digital activism. So let's just focus on this free speech question right now because Catherine framed it nicely. It sounds like there are free speech interests on both sides of this debate. On the one hand, opponents of SOPA said it would lead to a less open and free internet by changing the structure of the net. On the other, Stephen says, citing the copyright clause, that without copyright protection, artists and creators won't create good material to begin with. Which side do you fall in that debate? And does either of you have any empirical evidence about whether it's true that you need copyright to get journalists to write and people to make movies and so forth?
Well, that's not a question that I would be competent to answer. I mean, we are, that's just not something that I would take a position on. I mean, I think that the First Amendment argument is not appropriate in this context. I do believe, as Steve has already indicated, that First Amendment is part of copyright, so they're not in tension. What I guess perhaps part of my frustration right now is that there are, as was during the legislative process, a lot of points that are dropped out and unresponded to. Larry Tribe wrote a letter, so did Floyd Abrams. You have competing First Amendment people who have come out with intellectual heft, who came out and gave their opinions, and they were carefully weighed by Congress as we went through the process. Secretary Clinton also wrote a letter to Congress indicating that there was no tension between the protection of intellectual property and an open internet. She did not see those as being mutually exclusive and that one should not take precedence over the other. Just a little bit about the legislative process throughout all of this. I also just feel compelled to say, many of the things that we did in SOPA, and it is true, and I appreciate Steve for doing a better job than I did in laying out. I was a little, being the first person, it was a little tough there. But
Thank you for doing that, by the way.
Yeah, no problem. There were two components to SOPA. There was an Attorney General section that gave the Attorney General certain tools to go after websites akin to those that Steve has mentioned are available to governments around the world. Then there was a second section that set up this kind of marketplace where it was a private rights of action section, basically. That section was, as the bill was introduced, was controversial. But that section was developed in reaction to folk here at the table to the Senate's bill. The Senate's bill had already passed. So we were trying to make compromises that would get a new bill through the process and would actually pass in Congress based on the concerns that we were hearing from tech companies, from payment processors, ad agencies. We were trying to address those issues in the House drop bill because of the concerns that had been expressed with the Senate's bill. There are so many other things here that I would like to talk about. So as the bill was introduced, I think there were some concerns as we moved through the legislative process, as with all other bills. Amendments were being offered. The manager's amendment addressed a lot of the questions and concerns that had been made. And the netizens, if you will, did poison the well. But a bit about that as well. I want to just, I was listening to, can I say that, NPR a couple of days ago.
Of course, it's the
And-
American Constitution Society.
Okay, all right. And,
Aren't you required to
they-
listen to it?
They were doing an interesting story on the like button on Facebook. And what has emerged as a market economy for some companies is that they've hired people to like things. So you don't know whether the volume of information that you're getting is truly, I mean, the reliability of the internet is at risk, I would say. You have 20,000 likes that may have been all liked by some, undergrad sitting in their garage. I mean, we don't know what all of this, what the numbers mean. We just don't. There is certainly a feeling on Capitol Hill that the internet response was orchestrated and orchestrated by misinformation to people. How many people in here wrote to the White House or went online and?
Oh, wow.
That's fine. It's not a majority.
How many read the legislation or, looked at it?
Of those who said, yeah, we can have a whole lot of Q&A here, but.
Come talk to us later.
Yeah, exactly. So in any event, I mean, I guess there are probably other people who want to talk, but the problem remains, and I think that Congress and as Steve said, champions of the First Amendment, like Senator Leahy, like John Conyers, like my boss, Mr. Watt, will continue to find an answer to this problem as well.
Gregory, I want your response to all these points, and may I ask you to drill down on this question of the degree to which digital activism has changed the debate. Stephen compared it to a barroom brawl. He said it was a blackout followed by a mugging. Was that that was wonderful. It was a very helpful intervention in metaphors. Actually, that's almost like the broccoli metaphor. Maybe this will be a meme that'll work itself up to the Supreme Court from your lips. But was that your perspective? And more broadly, were you surprised by the degree to which netizens changed the debate, and will they change other debates in the future?
Sure. Let me just very quickly touch upon the free speech issue, if I could.
Sure.
And I want to agree with a point Steve made. Those who engaged in copyright infringement do not enjoy some type of First Amendment protection. The bigger problem is when you see overly aggressive enforcement that lacks due process and the potential for that to lead to some type of censorship. Case in point, I mean, we can talk real examples, real world examples. The Jazz One. I think everybody's heard about that music blog site now. It is a site that the government suspected engaged in copyright infringement, and the government's suspicions were based upon correspondence that occurred between ICE and the Recording Industry Association of America. And unbeknownst to the owners of this site, they come to work one day, and the site has actually been seized. It's no longer operational. Now, what happens? Now, if you read the affidavit, there were several items that were posted, sound recordings in particular, that were posted on the website that, again, were believed, suspected to be unlawfully obtained and unlawfully publicly performed and or downloaded, or made available for downloading, I should say. Fast forward a year later, so from the seizure, year later, the site completely, the operators of that site can't function, can't operate. The blog allowed for a lot of writers in the music industry to post their thoughts, concerns on topics ranging from, mainly this site, again, if you guys aren't familiar with it, it deals with hip hop, a little bit of jazz, but mainly hip hop. So all of those users who normally provide editorial content have been censored. Their platform has been taken away from them. If you look at the Protect IP bill as it was originally introduced, and again, it's hard to have this conversation here because, you know, and to Stephanie's credit, I just want to say the House Judiciary Committee did, after a not so good bill was introduced, borderline horrible, which may have deserved a brawl fight, although we didn't take money out of people's pockets at the end. At least I don't have any more money at the end of that brawl, but I think we may have won. But they made a lot of changes, but if you look at the Protect IP bill, that bill, when it was originally introduced, it allowed for in-realm proceedings. Now, this room, I believe, is filled with lawyers. That in-realm is not a way to actually have intelligent, articulate, educated conversations about whether or not infringement has taken place. Because it doesn't give the owner of a site, in many cases, the chance to come forward and explain how exactly a particular material was obtained, how it's been used, whether or not it's authorized. So it would actually take away due process and could lead to, in fact, more censorship. And so that's a point that we were trying to bring out. The point about digital activism, is there hyperbole? Yes. But it exists in every debate. I mean, we could talk about Obama's healthcare law. I mean, there's no end to how this process unfolds. What I will say is, you know, you hear people all the time talking about the advent of the VCR and how that will ruin the film industry. You hear about going way back to broadcast radio and the impact that that will have on the distribution of musical compositions. There is hyperbole that has taken place and existed for a while. So I don't think that has much credence when people trying to argue that, oh, well, you know, and let me be clear, we never talked about breaking the internet. But I don't think that has as much credence as some of the people would like to suggest. In terms of digital activism, I think what really has occurred that has not been acknowledged by many of the supporters of SOPA and Protect IP is that there has been a groundswell of opposition to the way in which our copyright laws have developed for decades and for years, maybe not decades, but for years. And I think this was the first time where you could see a lot of users able to express their opinion. Were they fully informed? Did they take the time to read? I think SOPA was about 80 pages, maybe not. But they read enough to get the sense that this law was going to make it harder for them to gain access to legitimate content and make it harder to engage in fair uses of copyrighted material.
Well, you know, Congress was criticized for not being tech savvy enough, but I mean, I'm just here to tell you, and it's that the calls that we got, the letters that we got were equally uninformed. They were not, people had not read enough to know what the effects of the bill were going to be.
Stephanie, can I ask you and Catherine, has this changed the debate about digital civil liberties more broadly? I was struck that in the debate over CISPA, the cybersecurity bill, President Obama threatened to veto it, clearly moved by activism on the net. He's not consistently defended digital privacy before, but he seems to have switched his position because of net-based pressure. So has this changed our debates more broadly?
Well, yes, it has. I mean, you know, next Tuesday we are having a hearing on privacy over the internet. Everything that concerns the internet is now subject to the SOPA label. Steve talked a little bit about international effects. You also have currently the administration is negotiating the Trans-Pacific Partnership and the ACTA, Anti-Counterfeiting Trade Agreement, and similar arguments are being made with respect to those negotiations. And I think similar arguments that are not they're bogus arguments. I'm just trying to find
Catherine and Steve, I know you want to get in. Catherine, has it changed more broadly? And are there issues, this time Google and the net were on the same side, but are there issues where the activists are not on Google's side?
So I guess to your first question, I do think that the kind of mass constituent outcry and outreach has kind of fundamentally shaped now here in DC how legislation that affects the internet is being discussed. I think the big kind of upshot or key takeaway is that there are more stakeholders. And I can understand why here in DC it might seem like, well, you know, usually these deals do get bargained by a couple companies coming in and you strike a deal. And if this thing happens, like there must be a company or two behind it. I think to us, watching what happened on January 18th and the events leading up to that, there was actually a censorship day in November when there was a hearing in the House Judiciary Committee on SOPA. It kind of grew over time. There was a markup then at the end of December where hundreds of thousands of people were actually watching a webcast of a markup, which is quite unusual.
Imagine them watching one of the American Constitution Society panel. It would be a similar kind of soporific event.
Probably not at that volume, but yeah. But I think a couple things. I think for folks that have grown up with the internet, it's not just some like esoteric policy being written. It is your identity. It affects how you communicate with your loved ones every day. It affects what type of information you're getting. And so people love the internet and they feel very invested in it. And when there's legislation that might in the past have been looked at as kind of very technical copyright, when it affects internet policy, there is a new group of stakeholders that really truly care about it. I think, you know, for us, having those voices also participate in the debate, having more transparency about what the words in the text say and do, I think on balance is a good thing. I think if you look at just the sheer volume of what happened in January, it's pretty difficult to come away with any other conclusion that it was a very organic, extremely decentralized, rapid movement. If you look at how many different tools websites created to facilitate their users to contact Congress, there were something like 40,000 sites. There's 3.9 million tweets on Twitter that day that were SOPA related. Something like 162 million people went to Wikipedia, learned some information, and of those, 8 million people looked up contact information for their congressional representatives. The petition that we ran on Google got, I think it was, 5 to 7 million signatures. There were folks from Move On and the Tea Party working together, ACLU to Heritage. I think if you look at kind of the librarians to venture capitalists, artists, musicians, if you look at the kind of broad array of how many people this affected, it is the only takeaway I can have is that there are now a lot of people that care about this, and that has going to put some pressure on the way things were done in the past, and some of those might be inconvenient, and some of those are going to lead to more effective, kind of better legislation.
Fascinating. So, well, Steve, we have those numbers. Move On and the Tea Party dancing cheek to cheek. Who could possibly object to this wonderful effulsion of net democracy? Maybe
Well,
you might have a few objections.
Well, yeah, I think I think it is correct that this may have changed some things. I mean, I don't think this is an isolated example, and Stephanie mentioned the Trans-Pacific Partnership and other international agreements that are being negotiated, and there's this revolution of rising expectations about transparency, and whether it's justified or not in some objective sense, or whether it's going to lead to better policy outcomes or not, which I think is very much an open question, it's there, and I think it is going to affect the way we do things. But let's not get too carried away about this is, we're at the beginning of a new era. Everything has changed overnight. You have a situation where there's a disruptive new technology. There's people using a network in a new way. There's newly empowered citizens who are speaking out, and the intellectual property owners are fighting with them. This describes a situation in Kansas in 1874. The disruptive technology was the sewing machine. The new network was Montgomery Ward selling those sewing machines to housewives on the farms throughout the rural America and using the railroad and the postal system to distribute this product. The intellectual property owner was the owner of the patent pools in the sewing machine. And the empowered citizens were the Grange, the agricultural consumer organization that for the first time admitted women into their ranks. This was 50 years before women's suffrage, nationally anyway, because the women were very much affected by what would be the price of sewing machines and could you get it from Montgomery Ward and just how did it work. So I shamelessly ripped this example from a presentation made by Brad Smith, the general counsel of Microsoft at a symposium a couple of months ago. But I think it drives home. I mean, I've got the poster here. By the way, the caricatures, the exaggerations, you can look at the posters here, it didn't have anything to do with sewing machines or Montgomery Ward. It was no white slavery, fight against foreign dictators. I mean, that's the way this issue was sold in 1874. So maybe there's nothing really new under the sun here. And it is worthwhile looking back, and before we assume that everything is new and we have to change everything about the way everything is done, it's worthwhile looking back to see, usually there is some precedent, and we've seen this in the copyright world. Copyright has faced many, many challenges from new technology over the years. So the phenomenon that Gregory describes about popular opposition and questioning of copyright is not really new. And it's had to adapt to new technologies and new market models and so forth, and I think it's done so quite successfully. So I think hopefully we'll see more of that in the future if that doesn't get short-circuited by, I'm not objecting to the fact that the debate that raged was not as well-reasoned and thoughtful as you're hearing perhaps from people to my left on this table. I wouldn't expect that, but I just think it was so far divorced from the realities of what the legislation actually said and did that it may have some permanent harm, at least in this area, in terms of trying to restart a rational conversation about it.
You know, that analogy is so interesting. I wonder if I could ask you to pursue it for one moment. It's true that the Grange movement, like the netizens, united economic populists on the left and the right, progressives and sort of agrarian farmers. But the difference is that the Grange movement was pro-regulation, it was protectionist, it believed in minimum wage and maximum hour laws, it didn't like the curse of bigness, it wanted to break up companies so that people could govern themselves, whereas the netizens are very libertarian, anti-regulatory, quite comfortable with Google running the world in many aspects, so less concerned about the curse of bigness. What's the difference between the Grange and the netizens?
Well, you're now getting way into your territory and off of my territory, but I'm
as far as I go. So
okay, well, there you go. I just think the analogy is that these are people who hadn't really been participating in the political process before, and this was all politically directed. The result was that the Democrats took back Congress for the first time since the Civil War. So it had a political impact, and one that we've forgotten, and who even knows what these issues were nowadays. All I'm saying is that this is not the first time we have faced this situation. I think we need to think creatively about what's happened in the past, and not just simply throw up our hands and say, oh my God, everything is totally new. We can no longer continue to legislate, or we can no longer continue to which is unfortunately kind of the short-term aspect of this. I hope we can get beyond that, put this in some context, and get that rational conversation started again.
I just want a point of clarification. You're right, and if I suggested that, people expressing obviously their perspectives is new, that's not what I meant. What I meant to say or suggest strongly is that there are these new technologies that allow individuals to communicate more effectively and to demonstrate that. What Catherine is talking about when she talks about all the new websites that were developed to allow individual users to express their opinion, to sign a petition, I don't think that type of infrastructure has existed before, and I think now members of Congress are feeling it in a more direct fashion. That's the new part of this, is technology being an overlay into the process.
Yeah, I also think it would probably be a mistake. I mean, for folks in the room here that are kind of looking at this as a model of activism and then, kind of thinking about how would somebody use this and on other issues that you care about, I think it'd be a mistake to have as a takeaway that this is just like a switch that can be turned on and the internet goes wild and legislation's pulled back. Like, that was a very exceptional moment, and it took a ton of work over months, in the internet space of various different activists, working in education, and it also took certain processes happening in DC that kind of led to that pressure and that pressure, so kind of comments and red lines being given in, and then not as many, changes, and ultimately having no one in the technology industry or no venture capitalists, joining some more of a consensus-based approach, saying like, okay, here's where we all can agree, I think that there's some benefits, though, of having more people participate. I think from a technological perspective, we're seeing new tools now that are actually really cool. So you can, if you're a legislator, put up, propose legislation in draft form, and you can actually interact with your constituents, and they can leave you comments and make suggestions. And I think the ultimate goal, there are some lawmakers are experimenting with that, is that you have more informed policy making. I think It also has introduced policymakers to kind of new constituents within their districts that care about other issues that they're working on. Some people have actually joked to us when they see us, they're like, hey, you introduced us to a whole new crowd in my district. And I think for especially young people who are feeling somewhat cynical about their ability to have an impact, from the people I've talked to, that actually has made a difference on a broader set of issues, but people kind of actually feeling like their voice was heard, has, I think, turned the corner for some people that kind of felt more disengaged to want to participate more. And I think that's great.
Wonderful.
Well, can I?
Go ahead.
Well, I think that one recent example, and Greg will remember this well because I think he was on the Hill at the time. I think, activism is welcomed on the Hill. We do appreciate hearing from from the public and what they're thinking. That cannot always dictate what policies we adopt in the space. But I will give you one recent example of another problem that I think that we continue to need to deal with, and that is performers' rights, ensuring that the Whitney Houstons of the world, or her estate, who takes a song and makes it so popular, obtains a royalty for her performance, as well as Dolly Parton, who wrote the song. Now, that debate raged a couple of years ago, and Black radio all but killed any efforts to ensure that performers got a royalty from radio. And what that message gave us, what the message was that kind of similar here: if you control the platform, you control the message. So, because the message that went out to Black radio was that, again, unfortunately, poor Mr. John Conyers was not a supporter of Black radio, when he was indeed trying to do what was right by artists. Same here with the internet. I think the message can sometimes get distorted, and people don't always go back and look at the updates, if you will. I think young people should continue to be engaged, but I also think that generation gaps aren't new. The fact that kids are really, you do have to go to your 10-year-old to figure out what's going on most of these devices, and that's fine. I think nobody is suggesting that the internet is not with us forever. The president just signed an executive order yesterday, I believe, that basically gets rid of all of the morass from department to department, so that broadband could be deployed more broadly. What's that going to mean is that more and more people are going to be able to get access to the internet where they otherwise could not, and that we as lawmakers, policymakers, have a responsibility to ensure that not only that we have broadened the access, but that what we're giving access to is safe and reliable and consumer friendly.
Great. Well, we have lots more to talk about. We've got another 25 minutes or so, including what bills you think should be adopted in the future. But I would like to hear from the audience, and I know you've got a lot of questions, so let us open things up. Great to see you, and please.
I have a comment. I hope you'll bear with me if I don't pretend to form it as a question, but I am interested in your reactions to it.
End with a question, and then, do it as a
All right,
comment.
I'll end with a question. I'll ask you what you think about what I just said.
Don't you agree or disagree? Yes.
Right, exactly.
You know how to do it.
When I listen to these copyright debates, I'm often reminded of that old New Yorker cartoon of the big fish is eating the medium-sized fish and saying there is some justice, and the medium-sized fish is eating the little fish. The big fish is saying there is justice, the medium-sized fish eats the little fish and says there is some justice, and the little fish, of course, says there is no justice. And, as a freelance writer, I'm a little fish. And from my perspective, Google is the big fish. The media companies that are carrying on about their copyrights are the medium-sized fish who are eating the copyrights of the little fish. So, I don't want to say that it's ironic. It's more like hypocritical the righteousness of some of these media companies and publishers carrying on about their copyrights and what they're contributing to free speech when they're really appropriating the work and the copyrights of individual creators, often for little or no money. And as a result, copyright is really being corporatized. And that is what I would like your reaction to. May I have your reaction to that, please?
You know what, Wendy, it's such a good question that I'm going to throw one back at you before they react. As a fellow little fish, I want to ask, if copyright were more vigorously enforced, would we, as essentially freelance journalists, get more money?
It's complicated because, well, there's a couple of reasons why copyrights are being appropriated. One, it's the result of the Ticini case, which was the classic Pyrrhic victory. The Ticini case was a really thoughtless, in my opinion, case by individual freelance writers, the Writers' Union, against the New York Times for illegally appropriating the copyrights of freelancers. So as a result of that, the New York Times and just about every other company decided that as a condition of writing for them as a freelancer, you had to sign away all your copyrights. Very few freelance writers know anything about intellectual property. Very few of them even read the contracts that they sign. So they sign these things, and they sign away all their copyrights for no or virtually no money. The other contributing factor is the information is free ethic, so that all of these websites now are not charging for access anymore. But somebody is paying for it, and the people who are paying for it are the individual creators who are working for free. I mean, information isn't free. My work costs money. The problem is it only costs me money. It doesn't cost any money to my readers. So I think the little fish, ideally you would say, well, the little fish have to stop signing these contracts. The little fish have to start insisting on holding onto their copyrights. That's not feasible because there are so many little fish out there now, and we are all fungible. And there's always going to be enough of them who will sign these agreements. I'm not sure what the answer is.
All right, so Catherine, you're the big fish, and it's all your fault that Wendy and I are struggling. We can't even feed our families thanks to this rapacious Google that is destroying the culture business, as Robert Levine says. What do you make of her critique?
Okay, so we disagree with Mr. Levine, clearly. I'd love to talk to you afterwards. My kind of quick feedback would be, I think for the little fish, there's probably never been a better time in the world. I think what innovation and technology has done is really, I grew up in an artist community. I think it has never been easier to produce your own content and also to distribute it to a mass audience. One of the things that we're doing from a YouTube perspective at Google is we're really excited that through the web, creators can actually reach a much greater audience than they had ever anticipated before, kind of at lower costs. And we are investing over $100 million in new original creative content for the web. So one of the things we're hoping that we'll do is create new kind of economic activity in the web content creation space for authors, for writers, for videographers. There are a lot of different monetization options right now. I do think technology is placing pressure on more established ways of business models. There's also a lot of really revolutionary, fascinating ways that people are, figuring out how to monetize and distribute their content. One of the things for the YouTube channels that I just think is really interesting from a nerdy copyright perspective is after the initial investments are recouped, the authors and the creators retain their own copyright. So I think if you are a pop star and you want to go big with a huge label and an established way of doing things, there is a model for that, and that is one avenue to success. But if you're Justin Bieber and you post your video on YouTube, you can also get discovered in that way. If you're an author that has something to say, you can publish to a global audience. The same thing kind of for sales and e-commerce. So there is no one path yet, but I do think there's a diversity of options, and especially if your content is directed more towards a niche audience, I think having a global audience is better for you because you don't need to have, say you write a TV show, you don't need to have everybody tuning in for your first 5 on NBC at 8 p.m. You can kind of grow an audience over time, or you can appeal to people that have your special interests. And on an aggregate basis, that could be enough to sustain your business over time.
Lots of other questions, so we don't need everyone to weigh in on this fascinating question, but assuming no one else does, why don't we have our next question?
Thanks. Great panel. I'm Shahid Buttar from the Bill of Rights Defense Committee, and I have a question, I guess, for each of you, but primarily for Catherine, relating to the outer limits of the movement that emerged to challenge SOPA and PIPA. You'd mentioned that it was an extraordinary moment that maybe is not easily replicated. And just to think about digital civil liberties in a broader context, the other particular dimension of digital civil liberties that looms large in my mind is the NSA's warrantless wiretapping scheme and the surveillance regime authorized by the Foreign Intelligence Surveillance Act amendments of 2008. And I don't think it's a stretch to say that people's online interests are implicated at least as much in that arena as they are by SOPA and PIPA. But there's a shroud of government secrecy surrounding the program. No one even knows its outer contours. What would it take, essentially, for a similar moment to occur in a broader context relating to digital civil liberties? And what explains the very different public reaction to these two very different but related sets of government initiatives?
That's really interesting. I think there's a lot of people that know a lot more about digital activism than I do that I'd love to know their perspective too. My sense is that part of what was unique about the SOPA moment is there was something tangible that people felt very connected to, that they loved very much, and they also felt a very direct and immediate threat. And I think in the policy space, kind of finding those moments is sometimes challenging when an issue is presented more as long-term consequences. So that's one thing that I take away from it. I think making a policy issue very relevant to users or to the community that you're trying to reach, is kind of an important element. I think another thing that is really unique about the SOPA moment is how truly big that tent was. And I think for anyone here that would maybe be more focused from a partisan perspective, I think thinking how big your tent can be on a policy issue is really important. Especially when it comes to the internet, I would completely argue it's not a partisan issue, it's bipartisan. There's so many different stakeholders there. And so maybe that means working with someone on a specific issue that you had never imagined partnering with. But when you can find kind of a common set of goals, that's sometimes worth it to kind of shine a light on an issue that you care about so much. Kind of when and how that moment would ever be replicated again, though, your guess is definitely as good as mine.
Yeah, I'll jump in just real quickly. I think secrecy and politics are the two reasons why you won't see what occurred with SOPA and PIPA transition into that area. Secrecy being because, and I think you alluded to this in kind of your lead-up comments, a lot of what the government does under NSA, FISA, the Patriot Act, is protected information, and you don't actually find out what transpires until there's some type of documented abuse. And the bigger problem with even trying to do some type of wholesale reform versus piecemeal, you may see a piecemeal like I don't know if you saw, I assume you saw the actual monitoring of the suspected drug dealer whose car was the Jones case. Thank you. You can, those types of incidents typically do bubble up eventually, but the bigger problem, as I see it, is our criminal law has actually been meshed with our actual terrorism law, and there are arguments for and against this. I mean, part of the thought is, you want to be able to investigate the criminal side to lead into the terrorism side. But because they both are tied together, the notion that there could possibly be some type of grassroots uprising to address that larger issue, I just think is very unlikely for the political reason. You're not going to get members of Congress to actually go before the American public and say, we want to roll back some of these protections that could potentially protect the larger society from the future threat, the future terrorism incident.
And I would just say, again, I mean, depending on, on the message, look, bringing it back to the origins of this activism with SOPA, had I not been on the Hill and just, in my personal capacity, heard that the internet was going to be broken and free speech was dead forever, I too would have become one of those activists. What concerns me and worries me, and actually worries, quite frankly, some of the engineers that were against SOPA, is that the activism that has emerged could indeed scare members of Congress again, even if the message isn't right. You know, if the message is, well, the argument that we've heard is that the genie's out of the bottle and that even Google won't be able to rein in netizens when they are on the wrong side of the issue from their perspective. So, you know, there is a concern that we want to hear from people and know their valid concerns, but just the internet is a very anonymous, you know, place, and it's hard to kind of sift through what's going on there. As a legislative aide too, I will just be very upfront with you. This is an election year. So in election years, when you have that kind of reaction, it does affect how individual Congress people respond.
Steve?
Well, I think, really going back to the previous question, one factor here is the big fish do tend to shape the message. And Catherine's company has a much bigger megaphone than all of my companies, the companies I represent, put together at this point. And I'm not pretending that, you know, I'm not saying that any of this was, you know, someone was sitting in Mountain View dictating this. That helps to shape the discussion. And I mean, if you think about what was said about these pieces of legislation, for example, I heard, you know, I turned on NPR, which is my main source of information also, and I heard that someone who ostensibly had read the legislation said, well, you know, under this legislation, the internet service providers are going to have to look at every email message and try to decide if there's anything infringing in it. A fantasy. B, very close to what Shahid is talking about. That's where that meme belonged. Somehow it got attached to the wrong thing, and I don't think it was totally a random act, but I think it's difficult in an environment where there is, you know, I just think the ability to generate this, I get it that there's a very strong grassroots aspect to this, and I'm not trying to minimize that at all, but at the same time, as I think you said in the introduction, there's some very strong economic interests helping to steer that.
I mean, the one thing that I find kind of hard to believe, though, is that the media companies themselves had trouble finding distribution channels for their message. Like, that, to me, is a little bit hard to square with. I mean, I remember during the, I think it was the fall, there was a GOP debate on Fox, and the moderator asked a question about SOPA, and there were boos, and every single candidate came out against it. But the moderator began by saying, my corporate parent News Corporation supports this bill. Here's the question. So I don't think that in Washington there was any kind of dearth of having communications from any of the major players here. I think what was kind of unique was more smaller entities speaking up and actually having their voice heard as well.
Well, there was no dearth of Congress hearing from those entities, for sure. And I agree with you that I think that the medium fish could have and should have done more to educate the public about what the problem was, and that did not get done. And I also believe, I think I started, not as somewhat ineloquently in my description of what we were trying to do. I think that the trademark owners bore some responsibility to get out there, but I also appreciate that, you know, you don't want to go out and say that X toothpaste has you know, mercury in it, because then any sensible consumer will go to Y toothpaste. So there, you know, we understood what the problems that the trademark owners were having in forging together with movies and music to try to get a sensible piece of legislation passed. But that message didn't get out to the public, and that's unfortunate because, you know, again, the problem persists, and it does pose some health hazards to you, to us, to all of us. It poses problems for the military. There are counterfeit military goods out there. There are counterfeit goods that go to firefighters to, you know, a firefighter comes in to save your home and his equipment doesn't work, you know, we're all victims of that.
In the Netizen spirit, we've got 10 minutes and a whole bunch of questions, so why don't we take 2 or 3 of them at a time, and then we can have our panel respond. Please.
Try to speak fast.
Just short.
Okay. My question goes to how do we move forward? And I guess what I'm focusing in on is that part of the problem in terms of what caused the controversy over the legislation, and it's a usual impediment, it's some people not listening, okay? So for example, I'll just take an example from today's discussion, right? One characterization was folks that were against the legislation were saying copyright equals censorship. Now, I don't think that that was ever what was anybody's point. Nobody was ever saying that. What was being said was that an improper interpretation and application of the copyright law can lead to censorship, because copyright works with the First Amendment by including fair use, and fair use enables you to make use of some other person's expression under certain circumstances, all right? But to equate that as saying copyright equals censorship, it strikes me as there's a certain amount of not listening or not hearing going on, and that's always going to be an impediment. So I've heard from some of the opponents to the legislation that we recognize there's a problem out there with, you know, extreme rogue websites, and there's something that has to be done. I'm interested in terms of those who were supporting the legislation. Did you hear anything at all that the opponents were saying that now you can say, oh, okay, I get it, and that you can take that back to new efforts to construct legislation to go forward? Because when you can hear something that the other side that was saying that you can finally embrace, it seems to me that that's a place where we can begin to move forward. So did you hear anything at all from the opposition that you could undertake?
Excellent question. Let's have just a few more, and then we'll repeat them and get some answers. Thank you for that one.
Hi. One of the most interesting aspects of the popular revolt against SOPA, for me personally, was seeing the way in which Google kind of stepped outside of its role as an impartial arbiter of information to kind of using its reach to push forward its own policy agenda. And in some ways that was kind of scary, but in some ways it was also really cool in the sense that it showed that Google was not only really capable, but also willing to use its reach to advance policies, which I personally am in favor of. And so in that sense, I was wondering both whether there were some internal debates within Google, about whether or not that was an appropriate thing to do, kind of stepping outside of the Google public policy blog and reaching out directly to the audience in the search services, and also for everyone else on the panel, in light of the topic of our convention this year, what the implications are for democracy. I know a lot of legislators kind of expressed surprise at the power of Google in this particular episode. So.
Very interesting. I know Catherine and others will want to address that.
Hello. Sorry, I actually had 2 comments and then a question.
Actually, we're getting tight, so the
Okay.
question would be better than, sorry to
Just the one, well, the one that's really short.
Sure.
IP, when someone, you know, someone infringes on copyright, it is not theft. It is infringement. They're different words. Please stop saying it's theft. You use the word theft, you use the word steal. It's just not the same thing. That's the first thing. Anyway, the question I wanted to ask was for Ms. Moore. You seem to be talking about netizens as if they're sort of a separate thing than other grassroots movements. You referred to the same thing happening on Black radio, because who controls the message, or who controls the media controls the message. I want to know why you think that's different in those cases than every other democratic action ever. I mean, I think if you had, yeah, I'll just leave it at that.
Great. You know what? These are also good. Let's get 2 more, and then we'll get our final answers in a comprehensive way.
Hi, my question is also for Ms. Moore. And you seem kind of exasperated that people that activists have kind of come to challenge these bills without really knowing a lot about the substance or the rights that are at stake. And my question is if you think that the government could do more in educating people about legislation itself without people needing to log on to Thomas and read an 80-page bill and have a substantive background in copyright to understand what's happening. Thank you.
Very good. So let me just sum up those excellent questions. The first was, did proponents of the bill learn anything from opponents, and how could that be incorporated moving forward? Then we had a question specifically for Catherine. Google abandoned its neutrality and used its power to advance civil liberties. Here it was good, but in the future might it be scary? There were two questions for Stephanie. Doesn't control of the medium always lead to control of the message? And what can government do to educate people about legislation? And then a broad question for everyone about implications for democracy. So I think we're going to just each have one final round and then wrap up. Stephanie, you had those two questions. What are your thoughts on those?
Look, I'm not, anti-netizen, and it's interesting to me. I was at another speaking engagement, and it's not useful to try to characterize, what I'm feeling or, feeling. I think the netizens are a powerful source, but I also think that again, from a policymaker's perspective, form letters, it's not unlike some other grassroots movements to me. Again, as a policymaker or assistant to one, just the volume of the noise can't dictate the result of the process. It's something to listen to, but it can't be definitive from my perspective. If there is a legitimate policy objective, the fact that people more people are interested is compelling, and it makes you take a second look. I'm from Birmingham, Alabama. There was this thing called mob rule. It's not always right.
Gregory, you can take any of those, but maybe the proponents learning anything from opponents and vice versa, and where you'd like to see us going forward?
Well, if I can, I think I want to jump on, the last point you just mentioned, where do we go from here? I think there have been a lot of productive developments in the last few months. One, the announcement that the ISPs and a lot of copyright owners have agreed to launch this new copyright alert system. Advertisers have decided to work to make sure that ads aren't placed on illegitimate websites. And third, payment processors have agreed to stop processing transactions that are associated with illegal online pharmacies. I think we need to do a lot more of those, enter a lot more agreements. I also think Congress has to be more proactive in updating current law with respect to statutory licenses. We've got to find a way to make it easier for legitimate online distributors, music, movies, ebooks, to get that content out to the general public. This hasn't been addressed in over a decade now, and it's just time for that. And I think that's the best way to reduce online piracy.
Great. Catherine, should we be delighted or terrified by all-powerful Google?
So just picking up on what Greg said, I do think kind of absent the legislation, there's a tremendous amount that can be done on the issue, both on the enforcement side. It's something we take incredibly seriously, devote tons of effort into. And I think also equally important, making sure that there are legitimate offerings that are available online to people that want to consume, they want to purchase, but they want it on different devices and they want it in a user-friendly kind of compelling way. One of the things on YouTube that we've designed is something called Content ID, which does give rights holders the ability to kind of control how their content is used and also to find new revenue streams. So the number I just saw the other day was we are now sending checks from YouTube to folks in the music industry that equal hundreds of millions of dollars a year. So these are new streams that hopefully will grow, kind of expand the web for everyone. It's good for us. Obviously, we take our share. But as the web grows, there are a lot of people in the ecosystem that benefit. I think your question about the decision to use the homepage as a promotion, I will say, I mean, from the company's perspective, it's not something that's taken lightly. It's not something that's done, on a weekly basis. I think there were a couple of different factors that led into that. One was the feeling that we had worked, that we could honestly look at ourselves and say we had tried in good faith for months, for like 8 months, to get to a place where we'd all have a bill people agreed with, didn't have collateral damage, and would pass for the right reasons. That goes from making phone calls to participating in hearings to giving red lines to spending so many hours on trying to find an alternative solution, including supporting the Open Act. It also, at a certain point, we were hearing so much from our users about how concerned they were for what this would do. And I think from our founders' perspective, yes, they are Google now, big, successful company. Not that long ago, like 10 years ago, they were guys in their garage. They were starting YouTube. They were starting Google. And when they're looking at internet policy, they look at it through that lens. And what will this do, not just to the big fish, but what will it do to the kind of upstart emerging company if the balance is not struck? For innovation, you need to let technology companies like that breathe a bit, so that then you can kind of move forward and have something more sophisticated like the Content ID. So I think they felt like at a certain point they were hearing so much from users. Users were feeling like they weren't being heard. And then the question was, well, there is this web protest that's happening on January 18th. There are these others. There's Tumblr, there's Reddit, there's a whole bunch of sites that are leading this. As Google and Facebook and Amazon are looking at this, they made the decision to be part of that movement, rather than sit out. I think it was the right thing to do. They obviously had to figure out, well, then what is the right mechanism? There are tools you could enter that would have everybody easily call Congress. What might that do to the phone lines for other business and work that you have going on? So there was kind of a careful balance between also how that advocacy would be done. And we felt like having a petition was the right way to strike, showing the huge volume of people that were concerned, if they were, with also letting Congress proceed with all of its other, important work.
Steve, the last word is yours. Take it away.
Okay, and to the question of whether, from the proponents, did we hear anything that is a basis for moving forward? The answer is clearly yes. The noise-to-signal ratio was not always very good, but I think we did hear some things. First, several people have mentioned this, and we knew from the start. The issue here is the definition and making sure that you have a good, focused, but also practical definition of these sites that we're after and that we all recognize, I think, are still a huge problem. So I think that's an important area to focus on going forward. Second, a lot of the opponents of this legislation said they were happy with a follow the money strategy with new tools to try to deprive these sites of some of their revenue. They just couldn't get behind any of the other remedies that were so objectionable. But follow the money is an important part of this. It's not the whole thing, I don't think, but it's certainly an important part. And some of the voluntary efforts that have been mentioned with advertising and so forth are very important. The question is, how can we go beyond that and give even further impetus to getting these companies out of the business of depending upon revenue or deriving revenue from criminals? And I disagree. If you look at some of these sites that we're talking about, this is theft. This is stealing. This is not simply infringement. If we're just infringement, I think it should be a totally different story. The final point really comes back to the first thing you said, I think, Jeff, one of the first, which is the role of foreign governments. This legislation was put forward because the U.S. courts didn't have enough tools to deal with these offshore sites. And people said, well, we should get the foreign governments involved. And I guess my reaction to that is, kind of what Medvedev said to Obama, I will deliver your message to Vladimir.
Thank you.
We have been working for 30 years, literally, to try to get foreign governments to adopt better copyright laws and to enforce them. And it would be great if this were something that Google and others on the other side of this issue actually could join hands with us and try to achieve, because I think it would be definitely good for our economy, for American creators, for American innovation, if we could get some of these extremely recalcitrant governments to enforce these laws. Now, I have to say the initial signals are very bad on this, because the first thing that Google did after the end of the SOPA phase, was to work on torpedoing the only international agreement that was on the table that was addressed for doing just that, and that was the anti-counterfeiting trade agreement. But I'm hopeful, I'm remaining optimistic, that since we agree that there's a problem with these offshore sites, and since we agree that part of the solution should be to get those governments to crack down on that criminal activity, let's see what we can do together on that.
I mean, just on the law enforcement piece, I did want to echo international law enforcement cooperation between the U.S. and especially the allied nations where some of these sites are coming. That is something we support full-heartedly. In terms of us and our role, I mean, we work day in and day out with law enforcement as you know, in cooperation both domestically and internationally. So there's no like unwillingness to pursue smart strategies around this problem.
Ladies and gentlemen, I will confess that when I saw the title of this panel, I thought that it might be a wee bit technical, but in fact, it's turned out to be a vigorous discussion on the future of the internet and democracy, and that is because of our excellent panelists. So please thank me. Thank you very much.